have you kept up any of his teachings?
I have, yes.
It's good to know. Chris, Nick, at the beginning of this case, I will be clear, I had a totally different view of your claim. I had real concerns about it, and my main concerns, which still remain, are that the services that you were providing Chris were not in writing. That is a very big problem. And it's especially a big problem if a respondent in a case like this says, he's charging me for something I did not agree to. It is incredibly important that you explain exactly what you're going to do and put that in writing with Chris or any other client. When Chris initially put in his reply to these proceedings, he said he didn't have confidence in exactly what he was paying for, because when the bill came in, you confused matters by saying things like, in addition to providing personal training and providing personal chef service, I've also increased your confidence, and he shouldn't have to pay for that. In other words, you confused things when the bill came in. However, in the course of these proceedings, he has conceded that he was, A, sober enough to make the initial agreement, that the £2,500 was for personal training, which you fully provided, and also for providing what I'm going to call a healthy personal chef service. That was the beginning, the middle, and the end of what he understood you were going to provide. You gave him that service, he has admitted, in the course of this case. His life has improved as a consequence. That is an enforceable verbal contract. In the circumstances, therefore, I have to say, reluctantly, and against my initial judgment in this case, this court has to award you, Nick, the full value of your claim of £2,500. That's the order of this court, a reluctant £2,500.
Nick won his case and was awarded the full amount of his claim.